SJC-12890, Commonwealth v. Nelson, Mora, and others.
Mr. Judge, you may begin.
Good morning, Chief Justice Gant, Justices of the Court, and Clerk Keneally. May it please the Court. Stephen Judge for the appellant Nelson Mora, and on behalf of attorneys Mark Miliotis and Elliot Weinstein for their clients, Randy Suarez and Lymbel Guerrero. The question presented here calls for the clear reaffirmation of a citizen's reasonable expectation of privacy and their right to be let alone in the face of the state's unreasonable, warrantless use of enhancing technology to secretly record our homes. The Commonwealth asserts that her citizens have no expectation of privacy from state acts on their front porch, and regardless of the means the state employs to search or the quality of information they seize. Article 14 protects citizens from government action. It assures us that we may be forever protected from unreasonable state intrusion. It does not equate the state with my neighbor. Over 50 years ago, the Supreme Court made clear that just because a third party or a police officer could have positioned themselves near that public phone and heard cats speak, the government nonetheless had no right to use covert technology to secretly record his words without a warrant. The same must be true today, or our privacy rights will have been obliterated by technology in the short span of 5 decades. Our founders feared government overreach, not nosy neighbors. Furthermore, no human being could do what these cameras are doing. The government asks for your suspension of disbelief in order that you may imagine a state full of superheroes capable of being invisible, leaping tall poles, without physiological needs or any other manner of human fallibility. Today, the Commonwealth proudly proclaims that it may secretly record our homes at their whim with impunity. The camera is not just a camera. It is an automated, unknowable, unreasonable intrusion upon our privacy. The police may zoom for detail, record and store images forever, and exploit them with technology such as facial recognition. It chills our sense of security to know that any officer may train such a device at our homes. That they may do so without a warrant evokes something different altogether. There is no respite for the citizen in this scenario. We are lulled by the state's invisibility into a false sense of security. This is the mark of a police state, not a free society. Dragnet spying is oppressive to our pursuit of happiness and offensive to Article 14's promise of actual security at home. Today, the Commonwealth violates our social compact and leaves us at the mercy and unfettered discretion of the executive and every one of his or her officers. To be certain, our clients have something to gain here today, but the citizens of Massachusetts can only lose. For what we seek is simply the preservation of those rights our society has historically enjoyed. Get a warrant. Considering the stakes in play, our ask is small. Thank you for your patience. I adopt the written brief, thank amicus, and invite questions.
Hey, Justice Link.
Yes. I have a few questions just about the cameras themselves. How high were they? I don't have any sense of where they were installed. How is it possible that you wouldn't see them? What do they look like?
So the cameras are at the top of the of an electric utility pole. So
now exiting
Elliot Weinstein.
Uh-oh.
So approximately 40 feet in the air. And your question actually raises a point of transparency that is part of the dilemma in this case. So the record places the cameras at the top of light poles. It does not necessarily specifically identify the manner of how the cameras are hidden. So I can speak to general experience, but it places them at the top of light poles.
But you don't actually know what they look like, or we haven't got anything like that in the record, what they look like, or where they were, or anything like that. We haven't gotten what where they're actually located in this case. Is that right?
No, and we don't, and part of the issue, as I said, is transparency. So that in response to discovery motions, in many cases, I have never been able to obtain the actual model, serial number, dimensions, that type of information. And while that is not in the record, that is my experience. And it's part of the government's intent to maintain secrecy over as much or as many aspects of their current surveillance techniques as possible. I understand their motive in doing that.
Yeah. All right. So you're saying basically they were not, as far as you know, they were not visible to the naked eye. Is that what you're saying? I'm just not sure what you're saying.
Yes.
All right.
Yes, I'm saying that it's unknowable to citizens to be able to determine when and if their home is being monitored digitally.
Yeah. Now, I'm interested in knowing sort of what was it the cameras were used to get? What kind of information did they get? What kind of that they couldn't have gathered through other traditional surveillance? What did they get they couldn't have gotten otherwise?
So they're gaining associations, identities, either via images of faces, license plates, but they're trying to put together a picture. And so they are learning about the routines of citizens to further their investigation. So it's both a routine and essentially knowledge of the comings and goings, the patterns, the associations, and then further through exploitation, identifying those associations and continuing over time to put together a piece. But at the outset, it is a window into the intimacies of an individual who they have targeted.
Okay, but let me ask you a slightly different way. I mean, they use these cameras, and the police got information, presumably, and they've used this information somehow in connection with your case, right? Or is it that you fear that they're going to use it in connection with your case? I'm not sure. I don't really understand what they're going to do with this information, what they've done with it.
So they have used it to further an investigation.
How?
Knowledge.
In what respect? Have they done it to get a search warrant? Have they done it to get something else? Have they used it in other ways?
They did eventually get various search warrants for GPS, wiretap, other technologies where this court has required a search warrant.
Yeah. I guess what I'm saying is, did they use it in a fashion that was, because I gathered from the Commonwealth brief, the Commonwealth would prefer that we not look at the possible uses of the technological enhancements that are out there, but to just focus on what it was that was done here in connection with the cameras. And I guess I'm sort of thinking about, is the danger because of the coupling that you can do with technological enhancements such as face recognition technology and such, or is the danger just in the gathering of the information?
No, I think it's both. I think the intrusion on individual privacy occurs at the outset upon the individual, but the intrusion is ongoing through that exploitation that you referenced. And whether it's facial recognition or digitizing and enhancing images in a way not previously possible, all of that, including our associations and what that information reveals and permits the government to then do. And in fact, in this case, the poll cameras are staggered, right? So it initiates at my client's home, and then over the course of 5.5 months, at least 4 additional cameras are set up at various times. And that is done through the totality of the investigation. But the record before the court is a narrow one. It's a clean record for the court to examine the general authority of the state to conduct this type of electronic surveillance. So I understand.
Go ahead. No, go ahead, please.
I was just going to say I understand Your Honor's question, and I just think that the record here is a very fundamental record, a very basic record. The government, without prior judicial approval, set up these poll cameras for various periods of time, directed at homes, and intended to acquire information about targeted individuals.
Let me ask you a question. You just said that the cameras they weren't only directed at the homes, or they were also in the curtilages, but they were also public streets as well. Isn't that right?
That's correct. So portions of
they were just photographing the streets. If that's okay, they could do that without a warrant.
I think, yes, that's fundamentally different question. So I think that depends on have they targeted a particular place or a particular individual, and then you get into all of the series of analysis about that within the public sphere. That is a different issue. I would suggest that that's a more difficult issue that takes in more factors and invokes less of a privacy concern. That's not this case. This case is a very targeted and directed secret surveillance at our homes.
Yeah. Now, suppose the Commonwealth surveilled their home for 5 months only to learn that the defendant had been away on, I don't know, on vacation the whole time. Is that still a search? They didn't get anything.
I think it is.
You think it is still a search? Okay. Now let me ask you too. You said there were wiretap authorizations and other search warrant like CSLI for CSLI and so forth. Was there any overlap with the poll camera surveillance?
So the poll camera surveillance was initiated first, prior to any seeking of search warrants of any kind in this case. Okay.
Now, so you don't know if there was police officers were able to conduct any in-person surveillance of them at the same time that their images are being captured in video recording?
That is not in the record. The record is a clean stipulation about the use of these cameras.
Yeah. Okay. It appears that only two of the defendants, Suarez and Mora, stated in their affidavits they had a subjective expectation of privacy. Does that matter that the third one did not?
I don't believe so. And what I would say with respect to Mr. Guerrero's standing is that he is no different in this case as a guest at a home or a hotel or a passenger in a car in Article 14 analysis of searches involving those locations. He is a guest and is subject to the searching and seizing of the state. So if this is an unreasonable intrusion, he has standing just like the guest of a home or at a hotel or a passenger in a car may, even if he is not the intended target of that intrusion.
Okay, and this is my last question. Now, take a look at the pictures of the houses. They're pretty naked to the passers-by, right? I mean, there's nothing by way of fencing or trees really to cover up. So does this matter? Does it make any difference? This is just so, because I think the Commonwealth is trying to make a big difference, a big deal about the fact in case law, it's never been overturned, this difference we have the cases are drawn between public and private areas. What you expose to the public.
So what I would say to that, Judge, is that burden that the government would like this court to place on ordinary citizens runs into multiple problems. First, I think it's a double-edged sword. Were we to require that citizens proactively take the initiative to protect themselves from secret video surveillance of their homes, we have to look at the economic disparity that necessarily would create. So, we would then be saying that our right to privacy in our homes depends on our ability to pay for and erect and have the space or the confines, depending on where we live, to erect those barriers. I don't believe that that's what Article 14 requires us to do. I believe Article 14 places the burden on the government not to reasonably intrude on that right.
Okay,
Now exiting.
Mark Miliotis.
I misrepresented myself. I actually do have one more question. That has to do with the differences between the cameras here and that in the United States versus Mora Bush, where it was described by Judge Young as being the video from the poll camera was not only continuous but also recorded and digitized, and that is captured every single second that passed over 8 months in a digitally searchable form. I wanted to know whether it was the same with the cameras here. Do we have a record for that?
It is. The stipulation includes the fact that all data seized was stored.
Was digitized?
It was stored and then placed to servers and searchable. So that right there requires the digitization. It is searchable data.
Okay. That was my last question then. Thank you.
Justice Gonzalez.
Thank you, Your Honor.
Thank you. Good morning.
Good morning, Your Honor.
So with respect to facial recognition and whether this could be exploited for that's nowhere in this record, correct?
It's not.
Okay. And then, well, I didn't hear your answer. So the next question. On the public view doctrine, you start with that, of course, and then you go through that analysis. But poll cameras aren't anything new, like license plate readers or facial recognition or GPS. We've had poll cameras going way back, and all the case law on poll cameras goes essentially against you, and that you are, well, Judge Young finds Carpenter changes that. So can you tell me how Carpenter...
Now joining.
Mark Miliotis.
Can you tell me how Carpenter changed that, or if it's your view that those cases were wrongly decided before Carpenter?
So I think that what happened, Justice Gaziano, is that over time, it became more and more apparent about how the use of this technology impacted our rights. I do believe that prohibited, and that's why I spent so much time. We spent so much time on cats in our original brief, because it is the unknowing nature of this secret surveillance that makes it so similar to cats.
But hasn't every court that looked at this issue ruled against you with cat as precedent?
They have, based on their interpretation of what public view means. I don't believe CAT stands for that. That this general doctrine that my neighbor determines the permissibility of state action. That's not what CAT stands for. When anybody in that public sphere, and CAT was a purely public sphere case. And so anybody, a police officer or a neighbor, could have been standing next to that phone and heard his words. The point of CAT was an attempt to maintain the equilibrium of the Fourth Amendment. And that's what we're asking the court to do here. What they said was, in spite of that fact, the government could not covertly record Katz's words. And that's precisely what they're doing here. So when you say...
You're not going to argue that Carpenter changed the law?
I do believe that Carpenter, in many respects, changed the law. And Judge Young's analysis lays that out. but I also believe that there is a fundamental public view issue that CATS has always stood for and represented.
So if someone has a house that's on the corner of a busy city street and there's a traffic camera, like there are on many city streets, many other streets, and we want to find out what happened, police want to find out what happened going back as far as the 2 weeks, as far as the information is stored. Can the police access that 2 weeks worth of data on the public camera without a warrant?
So I think that's a very different question, and then you get into the third party and the public space analysis.
So what's the answer to that question?
My argument is that they would apply for a search warrant by establishing probable cause to set forth for a magistrate why they want to access that data. And perhaps this court will decide that that analysis should take place under the mosaic theory, dependent on how much data they see. My position.
All the murder cases we have, which have traffic cameras where they said the blue car went around the traffic circle at such and such a time, all of those cases require a search warrant.
I'm not arguing that because that is not our case and those are not the facts here. That is a public via third-party analysis that is completely different than a targeted camera placed with purpose and intent of secretly recording specific individuals at their home.
Is a distinction between your case and Carpenter, in that Carpenter and GPS and in fact McCarthy with the license plate readers all deal with tracking someone in their whereabouts with enough information to equate the GPS device, where here we have a fixed location.
Are you asking me if those issues are analogous, or to speak to the distinction?
Well, both. I mean, what do you say to that?
Okay, so I think that the focus of that is, right, the unknowability of this. So I would say that GPS is the most significant comparison, or the closest, but even in that you have a physical device that could be found or located. They also involve public sphere doctrine, so it's our presence in public, purely public sphere places. And what is seized is a blip on a screen, 2 coordinates. Whereas in this case, this is a private sphere, the most protected private sphere, and we're getting rich video that can much more easily and in more ways be exploited down the road.
That's all the questions I have. Thank you, Judge. Justice Louie.
Good morning, Mr. Judge.
Good morning, Justice Louie.
In Commonwealth versus McCarthy, Justice Gaziano's case, we said that when the duration of digital surveillance drastically exceeds what would have been possible with traditional surveillance, that would constitute a search. And we have United States Supreme Court cases, including Florida versus Riley and Massachusetts cases, talking about helicopters flying over backyards and over farms. And that is not a search. Why is it here in this situation where we have don't have digital surveillance that drastically exceeds what you've referred to as the nosy neighbor would observe? Why is this different than traditional surveillance and would constitute a search?
So if I can speak to drones and officers on the street, I don't think that those two are necessarily all that different. And the reason is because if there's a drone floating over my backyard at less than 400 feet, I have the very clear and obvious opportunity to know that that surveillance is there. Just like with the officer on the street in front of my client's house with nowhere to hide. That is fundamentally different than the secret nature, than the lulling of a citizen into the false sense that they are not being watched at their home in order to record what they do when they presume or can reasonably presume that they are not being watched by the state. So I think that is a fundamental distinction. I think that over the years, public view has become a very quick and easy resort. But I don't think it applies for that very specific reason. And it was the covert nature of the employment of technology in CAT that caused them to make this fundamental shift. And they did that because they realized that they needed to maintain that equilibrium between surveillance and privacy. And so whether it's drones or whether you're talking about a neighbor who could never do what this camera can do because they're human, that is the fundamental distinction.
All right. So you mentioned that it's the secret nature of the police engagement here. Haven't police investigators been secretly observing people since 1789 without infringing on their constitutional rights?
Yes, and they should be able to continue to do that. Well, as they could then. And okay, I'm not suggesting that.
But your point, which I appreciate, especially considering the duration here, is that there's something going on here that's different than what state can usually do. But that sort of begs the question that Justice Gaziano, I think, was referring to as Carpenter, because didn't Carpenter make the big point of tying the narrowness of its decision to cell site location technology and indicate that it wasn't calling into question conventional surveillance techniques and tools that might have been around, for instance, since the police started hiding behind trees looking at houses in 1789?
I agree. In that analysis, again, we're talking about third party and public sphere, but with respect to traditional surveillance that you're asking about, I think that it's really dangerous for us to say, okay, if a certain technology simply exists for a certain number of years, then at some point it's like a patent on a pharmaceutical. The state can employ it without discretion and without limitation. I don't think that's the proper balancing act that's required to maintain the equilibrium of our privacy rights and permissible state intrusion as it existed way back when. So yes, while the police have always been able to conduct physical surveillance and attempt to hide and see how long and how much they could document and jot down and sketch out, this is a situation where over 240 years, that determination of what level of privacy existed then when Adams set it in stone occurred 50 years before still photography was even accepted. And what I think the proper analysis is today. Do we need to consider, has that balance shifted? Has equilibrium shifted? And our argument to the court is that this technology employed in this way, in this case, today, clearly shifts that equilibrium in a way that makes this an unreasonable intrusion. And all we ask is that they seek permission to do it. They're going to continue to do this.
Can they do it for 2 weeks without a warrant?
So I believe, and our argument, the appellants are arguing that the search and seizure occur simultaneously at the activation of the camera, because it is immediately looking for and searching on our curtilage information for investigative purposes. It seizes also what it's looking for immediately. Whether or not anything substantive is seized in that initial frame.
You need a warrant for 2 weeks. Right.
I agree.
No, I'm saying that's your position, right?
It is.
Okay.
It is.
With
and
the automatic, I got your answer. Thank you very much. With when you're dealing with whether it's the automatic license plate readers or the GPS or the CSLI, whatever it might be, there's a real concern that the government can go back in time and look at information about a suspect who didn't exist at the time the information was captured, and be able to put together a mosaic of what they've been doing, follow complex digital trails, and figure out location information. Whereas here, what you have is somebody that's already being observed by the police, and the technology, and this I think is the big issue that I'm trying to get at, that I want to specifically ask you, but here, with the technology that's very similar to what's conventionally been used for decades, if not centuries. So why is it that capturing information about a known subject in a place where the individual has exposed himself to the public, or his, why is that the same concern as what we've been talking about with GPS and CSLI? I think Justice Lincoln, or concurrence in Almanar, said that that was a situation where the government can find you anywhere at any time. Talk about the comparison of that technology in those cases to this situation, if you could.
So I think that they are fundamentally different, although, right, the compiling of this database permits the exact same future exploitation in many, many ways. That is, that you now have a database of however long this camera is running, which can be searched after the fact. A perfect record can be searched to cross-reference other information that becomes known later, whether or not any of this information had relevance at the time. So it is seizing and securing for later use in much the same way. And so for example, no camera targeted Mr. Guerrero in this particular case. But per the stipulation, his images were captured and stored on these. Now, the government was able to exploit that information. The record does not specifically reference that, but the record is clear. His home, I mean Mr. Guerrero, his home was not targeted with a camera, but he was observed, captured, and preserved on those cameras. So that would be one example where data collected over time could then be gone back and exploited. But
would he have standing relative to a camera where he's captured in Mr. Mora's curtilage?
Yes, we believe and argue clearly that there is no distinction in that situation that's present here for the court to a guest at someone's home where the police can commit an unreasonable physical intrusion, or a passenger in a car.
All right, I understand your standing issue as well. Thank you, Mr. Judge.
I guess it's fun.
Hi. I guess I'm trying to understand the difference between, you said that it's okay for a drone to do surveillance work and a police officer who may be on the street they're all quote unquote observable, right? So does the question that then boil down to the question that Justice Link asked, which was, can you see the cameras? And if you could see the cameras, if your client noticed the cameras trained on his home, would that make a difference?
I do believe that if the cameras are knowable as opposed to covert, that is a factual distinction, and then you are much closer to a drone situation or an officer in the street. And please don't misunderstand my reference to drones. I don't believe that is permissible. I'm saying that this situation is more extreme, is more of an invasion of privacy, specifically under the expectation of privacy test, because of its own unknowing and covert nature. So that's the distinction I wanted to make with respect to that. Not that I think ongoing or prolonged drone surveillance is okay. We don't believe that.
So then it doesn't matter if it was clearly a camera, anyone could look up and see, why is there a camera up there, trained on my house? That doesn't matter, you're saying. Either way, that would be invasion of privacy.
I do believe it's an invasion of privacy, but the unknowing nature makes it fit cleanly into a cat's expectation of privacy analysis. With respect to, let's say they posted a sign on the street, and they said every house on this street is under constant video monitoring.
Yeah.
Then you have much more of a situation that is more like public fear, third party, knowing surveillance. It's a different case than the very narrow record before this court. That's a different fundamental question. And it's not one that we attack, although I do think that is very fitting for a mosaic theory or aggregate analysis. And that, again, would require a distinct balancing test as opposed to the covert nature of recording our homes. It's fundamentally different. And if we're put on notice, then that certainly impacts that equilibrium. We at least have the authority to make choices, and our economy isn't stolen in that respect. We're not lulled into a false sense of security such that we feel that we are not being watched and therefore are free to do what we might otherwise not.
Because I'm just thinking, when you walk out of your house, you may or may not be being watched by your neighbors, and you know that, so you sort of take your chances.
That's true, but we're suggesting that it's a lot different to take your chances with a moment in time of a nosy neighbor and a 24/7 hidden eye in the sky of the government. Our position is that those two things just couldn't be more fundamentally different with respect to how they impact the balance of power in a Article 14 analysis.
Okay, thank you.
Justice Seifer.
Thank you, Chief. Good morning or afternoon. No, good morning. It's interesting listening to this and hearing you talk about equilibrium theory and mosaic theory, and what that tells me in the context of Carpenter and our recent cases is that we're at a moment where things are changing in terms of how we're viewing privacy, and maybe moving away from a reasonable expectation of privacy standard. However, the police are still operating under the assumption that if it's in public view and they have a piece of equipment, they can put it up. So isn't this a case where you could argue that the exclusionary rule should not apply, and this one's okay, but in the future, this has got to be done with a warrant because it's targeting an individual and it's collecting more data than a human could do?
So I appreciate that question, and our position is very clear on that, and that is that this court has not spoken to this issue. It hasn't addressed video surveillance of homes surreptitiously recorded for any duration of time. And so what the Commonwealth's suggestion and your question asks is, in the absence of a specific opinion from this court, is the Commonwealth free to employ new technologies without any fear of reprisal, even the fear of exclusion in one case, just one case? So are they free to exploit every new technology for a decade or 15 years until a specific issue reaches this court and this court has the opportunity to put the brakes on it? And Article 14 represents...
Counsel, I don't think I'm suggesting that, but I think, we do need cases to come to us, and it's only been recently that technology has started to dip in terms of its capabilities, and low cost for these departments, or for anyone. So I think that's another factor in this too. But because we haven't had cases on video camera surveillance until now, and why is that?
If you're asking me, part of it is because as the government employs new technologies, they maintain secrecy around that employment. They don't necessarily find it. And I'm not disparaging the government. They have a purpose, they have a method, and they have a means. They certainly have means to acquire all technology out there. And when they employ it, they are not transparent about it. That is their purpose. There may be a different public policy with respect to what's right for citizens, and there is a movement across the country to require now more transparency. But because at the outset those technologies are not disclosed because the government wants to maintain the covert nature, the unknowing nature of that surveillance, because in their interest, that maintains their effectiveness to the highest degree. So there is necessarily...
One other question, because I don't want to take up everybody's time, and that is with regard to this poll camera. This is a little bit different than the one that was in the federal district court that Judge Young wrote a decision about, because that one was focused, and this goes back to your economic argument, in terms of what one can protect and what one can't. But this was on a street and picking up many other things too, wasn't it? So, is there a difference between, I suppose I'm wondering what is the difference between this case and the case that Judge Young was presented with?
Well, I don't think there's a distinction in the sense that it captured the home and curtilage, the front porch of my client's house, others' driveways. It captured that protected area. So if certain public space movements with respect to a sidewalk in front of or a street adjacent to that,
would you be?
That
Go ahead.
So
you're saying that's just incidental, the extra stuff, the other people.
It is, and the fact that they could angle this camera and perhaps catch other spaces is again a distinction, but the primary targeting of the home is the most constitutionally significant issue.
Okay, do you think that we're moving away completely from a reasonable expectation of privacy analysis in these cases, these sorts of technological cases? Or is it a theoretical question?
We don't, and we hope that the court not. So we understand that because of the nature of the exploitation of technology, there are many more locations in the world that the police can access information than our home. Our home is a singular location for each of us. It just happens to be the most protected location. But we understand that most of the technology is being employed in public spheres and with respect to third-party information. We think there's a fundamental difference among that. And so that when it comes to the home, when it comes to those highly protected private sphere locations, that expectation of privacy is actually the most appropriate and significant analysis.
Okay. Thank you. I have no further questions.
Justice Kafker.
So my questions are, you're focusing, it seems to me, on three things: covert versus overt, the technology, and the duration. Let me just pose something, and I'm sorry, I've been stuck at home watching old movies. So stake out the movie. The police officers, rent an apartment across the street from this, and they have a zoom camera, and they're taking pictures of the house all the time. Is that permissible?
So that's an example of what the police employ when the police employ traditional surveillance, okay, in spite of the many practical impediments to that type of surveillance. And so the government has expressed and has shown a willingness to engage in that conduct with respect to activities of terrorism, of national significance.
But let me just, if they had done that to your client, they rented a house across the street, they have a zoom camera, and they're just taking pictures of your client. They think your client's a big-time drug dealer, and they've invested the money to rent an apartment across the street, and they're just taking pictures. They're not taking pictures inside the home. They're just taking pictures the way this camera was. Is that permissible?
So then the question again is the seizure of information captured from the home and curtilage by the government in private. So
it seems to me that's legal, right? There's nothing new about that. It's like Justice Lowy's. They've just got a zoom camera, which has been around since God knows when, and they're doing it. That seems permissible, isn't it? I'm trying to understand if that is why yours isn't.
There's a practical impediment to the widespread use of that traditional surveillance. The government could not, historically, nor has not presently, employed that type of costly surveillance across the board against her citizens. It's prohibited. It's not practically possible, and that is the rationale that Alito reiterated in Jones. So while things may be theoretical, right, history has recognized practical impediments, and that is the purpose of Article 14 and the Fourth Amendment, that those practical impediments.
So it's not that the technology is new or that it's covert or overt. It's the practical realities that police can't afford to do this without these automatic cameras.
That is a significant distinction, and is one that, many courts have recognized, and why the Supreme Court has said over time, as advancing and enhancing technologies become cheaper, more available, easier to employ, smaller in physical size, that we do need to constantly reevaluate their use in the context of what was historically practically
this is
doable.
Basically, this is a camera that's. This is just not that sophisticated a technology. It's just basically a zoom camera. But your view is that, and that gets me to Justice Gaziano's. What has Carpenter changed? Has Carpenter just changed that you need some novel technology, or has it changed our understanding of public space? That if the police keep focused on something that's public and learn a ton about you, it's a search, even if it's not new technology. That wasn't very articulate, but I'm just trying to understand, do you need a change in technology, or do you just need sort of sustained observation to get a search?
I appreciate that distinction, Justice Kafka, because the issue is all of that, right? So the sustained nature, the picture that is being formed, that is formed, is absolutely relevant. I don't believe that the newness of the technology, or a technology that has never been addressed before, is required. I guess the best way I can say it is, we look at these things not in a vacuum, but how they affect all of the things you just addressed in the context of our historic level of privacy. And so it could be any one of those things that shifts the balance. Here, it is the use of technology, the covert nature, the unknowing nature, the duration, but primarily the location that is being viewed, the intimate details that are being captured that could not practically have been done historically without significant impediments. And if that were the case, then why is the government not doing this? Why have we never seen a case where the government has done that? Because it's not practical. You know, a police officer can't put himself 40 feet in the air. He can't be invisible. The city can't rent houses all over town, but they can very easily deploy cameras on every light pole. They can very easily link those cameras via a network that is cost efficient, cheap, and creates a citywide database that can then do not only what was done in this case, to gain a picture of someone's routine at home, life at home, and associations, but also where all of that takes them throughout the city. So I think it's a combination. I believe that what is present in this stipulation before this court is an unreasonable intrusion upon our historic right to privacy that shifts the balance of what we expect from our government in a unknowing manner.
Thank you. That's all I have.
I have no further questions. Does anybody else have any questions? And hearing none, Mr. Judge, thank you. And we'll turn to Ms. Lymbel.
Thank you, Your Honor. May it please support Assistant Attorney General Anna Lymbel for the Commonwealth. There's been some discussion so far of practical constraints on law enforcement investigations. And so I think it's useful to talk a little bit about practical constraints on poll cameras that make them quite different from location tracking technologies, which this court in McCarthy described as tireless and effortless, and that's just not the case with poll cameras. First, for poll cameras to be a useful investigatory tool, significant law enforcement staffing is necessary. That's because you need to know what to look for in the poll camera footage. So it's been discussed here that the poll camera footage in this case was searchable, but the only way that the poll camera footage here was searchable was in the sense that you can jump to a particular date and time. That's the only searchability that was possible. So for that feature to be useful, you have to know what dates and times are significant, which means that the footage needs to be watched regularly. In addition, the zoom and angle movements that the poll cameras here allowed can only be made in real time, which means that an officer needs to be watching to use those features. So while a poll camera means that an officer doesn't have to be sitting, say, across the street in a car, that officer may very well be sitting in an office some distance away, requiring significant use of resources not associated with location tracking technology. So the idea that poll camera footage can be, say, collected passively over many months and then later reviewed is just not realistic. Second, as I believe Justice Lowy mentioned, law enforcement can't decide today that they want poll camera footage from 3 years ago before the poll camera went up. And that is quite different from location tracking technologies. As this court described in McCarthy and the Supreme Court discussed in Carpenter, technologies like CSLI allow the government to basically travel back in time and retrace a person's whereabouts, even though they had no idea earlier that they would even be interested in that person. With a poll camera, on the other hand, law enforcement has to make an affirmative decision to put up a camera, and only after the camera is installed does the footage become available. Third, these poll cameras have no night vision, so visibility at night is quite limited and is reliant essentially on there being some kind of light source available at the scene. And fourth, poll cameras cost money. This isn't in the record, but my understanding is that a single camera costs in the neighborhood of $5,000 or $6,000, in addition to a monthly fee associated with operating and data storage. So there are significant resource constraints associated with poll cameras. And that means that the prospect of, say, a poll camera being used in front of every house or a poll camera that goes up and never comes down is just not realistic. And with that, I welcome questions from the court.
Justice Link.
Well, good morning, or I guess good afternoon now. I have a couple questions. I'm very curious, we're all of us very curious, obviously, about what it is that these poll cameras can do, what their capabilities are, and so on and so forth. But it doesn't seem to be in the record. None of the things that you said, I think, were in the record, were they?
Well, some of the things I said, I think, are just...
well, I mean, that it was searchable only by date and time. Where is that in the record?
Well, the record says that it's searchable, so that is there, and I'm just describing,
I know, but I'm just saying that the record is very, 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 very sparse, it seems to me, on these questions. I mean, I asked, was it visible at all from the street, from anyone's point of view? And of course, that wasn't. I mean, your brother is basically saying, I don't know. And I guess I'm curious about how it is all of a sudden we're supposed to know from what you said. Where is that in the record?
On the point of visibility, I don't think there's any dispute between either party that the appellants were not aware of these cameras.
Not aware, but could you have been aware if you'd taken a look at it? What do they look like? What do they look like? How big are they?
So they're intended to be unobtrusive. They're intended to meld in with the surroundings.
Okay, let me just ask you a couple of other questions then. Was the video footage, you said it was searchable by date and time only. How do we know that there weren't other ways that the officers were able to filter and analyze it?
Well, Your Honor, I can represent that to the court. You're right that it's not the record in the record, but certainly the court couldn't infer from the record that there is some other way to search it. And I can represent to the court that only date and time searching was possible.
Okay, you collected ALPR data, didn't you? Police did collect license plate information?
I am not sure about that. I do know that there was GPS searching. There was a GPS warrant. There was a ping warrant in the case. So there were a variety. There were obviously search warrants. Actually, no, I can't tell you. There was no license plate collection in this case.
Well, to what extent were the cameras able to zoom and pan, and what was the magnification level available?
So they could zoom, and they could be angled in real time, as I mentioned, if an officer was watching at the time. But the zooming was nothing more than someone could see on the street. So you could zoom in order to see a license plate number, but that would also be possible for someone standing on the street.
So it's possible to see the license plate number, but you're saying it wasn't collected?
No, I'm sorry. They didn't use the ALPR system. But
did they collect license plate data?
I'm sorry?
Did they collect license plate data with the use of this camera?
Yes, they did look at license plate numbers.
Okay, and that was used to search for the owners of the visiting vehicles, right?
I believe, I'd have to check on that. I believe that may have happened, but separately, say if the license plate was collected, the license plate number was taken down through visible observation, and then that number would be looked up separately.
Was it somehow stored automatically into a database?
I'm sorry?
Was that automatically put into a database?
Was the license plate number automatically put into a database?
Yes.
So my understanding is a license plate number would be observed, would be written down, and then that number would then, through ordinary law enforcement means, would be looked up to find out who the owner of the vehicle was.
Well, I guess I want to know whether other state agencies or city agencies could search the database that you've collected in connection with the searchable video footage.
Certainly, there wouldn't be any way for other agencies to take information from the poll camera, if that's the question. The poll camera was used just for this investigation.
So it wasn't like in connection with the McCarthy case, collected and stored in various databases available to different law enforcement authorities.
No, certainly not. There's no such database. The footage in this case was used for this investigation. It's then stored for discovery purposes, but there's nothing like the ALPR database where it's something comprehensive that anyone in the state could look at. There's nothing like that here.
Okay. Was the first controlled buy with Mora conducted before or after the officers began the video surveillance of the residents?
There was a controlled buy through a confidential informant before the poll camera went up.
Before they went up. What period of time would it be separated, with the poll camera and the first controlled buy?
So I believe the first controlled buy through the informant was in November 2017, and then I believe the first poll camera went up in early December of 2017. Okay. So maybe within a month.
Before installing the video cameras, did the Commonwealth have probable cause to search the targeted addresses?
I'm sorry, could you repeat that?
I asked before installing the video cameras, before putting them in, did the Commonwealth have probable cause to search the targeted addresses that they did?
I think often not. A lot of the purpose of putting up the camera would be to collect information that would help to get a search warrant for the resident.
Okay. How about reasonable suspicion? Did you have reasonable suspicion before you put the cameras up?
Well, I don't know if you could say that. I mean, as I said, there was a controlled buy that tied Mr. Mora to drug dealing, but then part of the goal of the poll camera was to then tie Mr. Mora to his residence and the drug dealing to the residence, so that you could search the residence. But yeah, I think probably in this case, the reasonable suspicion standard was satisfied.
Okay. If you would, just suppose this case goes to trial in a year, okay? And by then, more technology has advanced, and the Commonwealth can use technology to enhance portions of the video recording, so that lip reading, for example, lip reading experts are able to recreate conversations defendants had on camera. Does that change the nature of the intrusion into the defendant's privacy?
Your Honor, I think that would be such a different case that it's almost difficult to answer. I mean, each of these reasonable expectation cases are very fact intensive, and if you're talking about lip reading, I think you would need to know some details about, how that technology works.
Well, that's one of the problems here. We don't really know how this technology works, do we?
Well, we do know how this technology works, but I guess what I'm saying is that it doesn't make sense in this case on this narrow record to try to analyze technology that certainly, as far as I know, isn't in existence, but it certainly was not used in this case and isn't in the record here.
Yeah, I guess what I was trying to explore with with your brother before, the whole question of whether or not there was the cameras themselves or there was a problem with the cameras in connection with the video enhancements that were possible, technological enhancements that were out there, possible in development, that could really construe these things in ways that would be very, very damaging, I think, to the individual. And I wonder to what extent we are not obligated to take into account what the possibilities are.
I think at this point that would be speculative, Your Honor, because we just do not have information about that technology, and every technology I think needs to be considered separately given the fact-intensive nature of these inquiries. It depends a lot on what the technology is and what it does.
I know it. That's what's so frustrating to me about how little the record is developed here. On the fact on how does this actually work? How is this different from, for example, a security camera? Well, is it different? Is it just like the camera that was involved in the Judge Young case? Is it just like that?
So I don't know the details of how that camera works, but one thing I will say about the Moore Bush case is that in that case, Judge Young said that the camera did not require monitoring in real time because there was a digitally searchable log, and that is certainly not the case here.
So you think it's not digitally searchable?
No. I mean, as I mentioned, the only searchability function here was that you can jump to a particular date and time. And that certainly wouldn't allow officers to not have to do monitoring in real time. There certainly was a need for monitoring in real time here. So to the extent that wasn't true in Judge Young's case, and I don't know, but to the extent it wasn't, then the cases are different.
How often, then, do you think that police officers monitored the video recordings in real time or manipulated the cameras or did anything in connection with gathering information that way? How often?
I believe so. I can't tell you exactly, Your Honor, but I believe they were monitored regularly.
What does that mean? I don't know, regularly. What does that mean, every day?
I believe it on a daily basis, yes.
On a daily basis. They were monitored every day on a daily basis.
Yes.
And that was when the officer could zoom or angle the camera to take the pictures that he wanted or she wanted.
It's yes to be able to zoom and angle, but also because that was the only way to know what was important. The only way to know what was useful to look at would be really to watch it in real time, and then to combine that with other sources of information. Once they had a wire, once they had, say, GPS, you could combine what you're learning through those other investigative techniques with what you're seeing on a camera, and through that get enough evidence for the search warrant.
Maybe you've answered this question already now. If you have, I'm sorry if I'm asking it the second time. Do you know what level of magnification was possible with this camera?
So, you're right, I don't have a number for you, but it wasn't able to see things beyond what a person standing on the street could see. So you could zoom to see a license plate, but certainly nothing like no kind of super magnification beyond what.
You couldn't see, for example, that somebody was speaking. You could not magnify enough to see their lips moving.
I mean, only to the extent that you might be able to see that through, if you were standing on the street, see that somebody was speaking. I mean, and in the appendix at page 89, you can see photos from the poll camera. So I think that gives you a sense of what the camera could see, and you can kind of imagine from there. It's essentially the same as someone standing on the sidewalk across the street. And
you're representing to the court that what the camera could catch was exactly what a human being could catch if they were standing across the street. No more than that.
Yeah, essentially. I mean, it's something that an observer on the street could see.
Okay. All right, I don't have anything else. Thank you.
Thank you.
Justice Gaziano.
I have no questions. Thank you, Chief.
Justice Louie.
Thank you, Chief. So there's a concern here that if for 5 months you're looking at somebody's house, you can get an awful lot of information that starts to put together the mosaic. And you take into account, our historical concern with the sanctity of the home and, cases on a different circumstance, obviously, like Commonwealth versus Blood. When you take all that into account, is there a concern here that because of advances in modern technology that an individual in a home has less rights than they would have had in 1789?
No, Your Honor. I mean, I think it's important to take as a baseline the fact that, as has been discussed, it's entirely permissible under current law for law enforcement to, someone to sit in a car across the street or in a house, across the street, and even videotape a person's house. And so that already is permissible. And it is true that here it was, for an extensive length of time. But first of all, I think it's important to remember that although it's 24-hour surveillance of a house, that doesn't equate to 24-hour surveillance of a person in the way that, say, the location tracking technology is. I think that nobody sits in front of their house 24 hours a day, and I think most people, are outside for a much shorter time than that. If, say, someone is outside their house for an hour a day, and I think that's maybe an overestimate for many people, that would only be about 4% of a 24-hour day. It's only capturing you during the time that you're within the frame of the camera. So if you compare it to the location tracking cases, you don't get that information about the whole of a person's physical movements throughout the day that you get with location tracking. And this court has generally said, even in McCarthy, the court said that whether something is knowingly exposed to the public remains a touchstone in determining the reasonableness of a person's expectation of privacy. So that's kind of the baseline principle. And the court has found in a particular category of cases where location is being tracked 24 hours a day, that those cases are treated differently. But I think this falls under the general baseline principle that applies and has applied, which is that this was knowingly exposed to the public.
So let me follow up on that. Knowingly exposed to the public, what the defendants are saying is you're not knowingly exposing this to the public because no human being or police force could put together the resources or be able to gather this in a clandestine manner. So that actually CATS has some application. Do you agree with that? Is there anything, or let me ask it a different way, is there, if the police were really concerned about this case so much that they want to invest 5 months into it because of the impact of at least upper middle level OxyContin dealers are having in Lynn, could they obtain this same information without this technology if they really wanted it?
Yes, I think they could. I mean, as has been discussed, you could, for example, rent a house across the street and, do a sort of stakeout and look at the house. The other point is, as I discussed, a person isn't outside their house all the time. So if you get a sense of a person's routine, you may be able to have that kind of physical surveillance for much less of the time than, 24 hours a day. In addition, as I mentioned, these cameras do not have night vision, and so a lot of what's available, there's almost nothing, very little available in the nighttime, even with this technology. And then the other point, Your Honor, is that the fact that a particular technology allows some law enforcement to do something more than they would otherwise do is not in itself enough to make it a search. I mean, just in last month in the McCarthy case, the court found that the ALPR system enhanced the abilities of law enforcement because nobody could sit on the side of a highway and capture every single license plate. But even so, it found no search. So just the enhancement itself can't be enough to create a search.
Mm-hmm. But McCarthy did raise the concern that through looking at complex digital trails and rummaging through information that we'd get all these records on an individual just going about his or her daily life. And why is that concern voiced in McCarthy not present here?
So I think McCarthy is distinguishable in a number of levels. First of all, one really important point is that it applied to newly emerging technology. ALPR is a new technology, just like CSLI and the other location tracking technologies. And I think that's really key because when you have a technology, as you do here, that's been around for several decades, then courts have had the chance to consider that technology, and Fourth Amendment law has developed along with it. But when you have a new technology, then sometimes you find that balance has gotten, unbalanced. And so you need to make changes to the law. So I think the Mosaic theory in McCarthy relates to that type of case, which isn't involved here. The other thing is McCarthy really emphasized this idea of location tracking and capturing the whole of public movements, which you don't do here. And then McCarthy also emphasized the lack of practical constraints on the technology, which, as I've discussed, there are quite a few practical constraints here. And then it also discussed the fact that you could easily look back, 3 years, even before you knew that you wanted to track the person. And as I mentioned, you can't do that here. So I think McCarthy is distinguishable.
That's an important point. One last question. I share Justice Link's frustration might be a strong word for it, but inability from the record to, for instance, compare this camera to the camera in Bush-Moore. But as far as Judge Young's opinion putting aside the First Circuit case, Boucher case, is there any, not United States District Court, but are there any United States Court of Appeals cases that have held differently in the context of these type of surveillance cameras and their use, pole surveillance cameras?
Differently meaning?
Different than Judge Young held.
Yes. Well, so just recently, actually, after our brief was filed, the Sixth Circuit in May Shaw found no search with respect to a poll camera. That was just, I think, the last 2 months. And then the Sixth Circuit in the Houston case in 2016, which we cite in our brief, and then the 10th Circuit in Cantu in 2017, the CANTU, and then Jackson, which is a case, back in 2000, which is a 10th Circuit case. So that, I think, shows you just how long this technology has been around. So in Jackson, the 10th Circuit found no search in the context of a poll camera.
Thank you very much.
Justice Safer. I'm sorry, Justice Budd.
Hi. So I was just wondering whether, if the police had, the budget, could they just decide to put up surveillance cameras across from every home and see what happens, see what they find?
No, Your Honor, they certainly couldn't. For the reasons I mentioned in my introductory comments, which is that there are a lot of practical constraints on this technology. The fact that there's a lot of staffing necessary, as I mentioned in this case, the footage was being looked at daily by an officer. In addition to the cost, this is
No. So first of all, this is a hypothetical. So this has nothing to do with what actually did happen. Although I understand that wasn't in the record. My question is, legally, could the police or the government put up a surveillance camera so that it's trained on everyone's home, just to see what they could discover?
So, Your Honor, I don't think there's a legal limit on that under the current law, but I don't think it's a realistic possibility. But I will say, if that were to become a realistic possibility, you could have issues with, for example, location tracking. Like if you had a camera on every house, then you could potentially track someone throughout their day from one house to another. So that would then potentially raise issues under, for example, McCarthy or under Carpenter. So I guess I slightly modify my point that it could raise issues under the current case law, under the court's current case law. But I do think there are practical limitations that would mean that would never happen, in the same way that, an officer could sit outside of every person's house in every neighborhood. There's no legal prevention of that, but there is kind of a practical reason why that wouldn't happen, and that's also true for poll cameras.
Well, but, technology changes, right? So, I don't understand why a poll camera would have to be monitored by, by staff, but let's assume that, you had a poll camera that detected motion, so that someone could go back and take a look anytime they saw someone come in or come out. They'd be able to see that, and they'd be able to see not only the homeowner but whoever came to visit the homeowner. So, I'm looking ahead, and I'm assuming that it can't be too far behind. I mean, you've got surveillance cameras now. They don't require constant monitoring. So I'm putting that to the side. I'm talking about whether it's legally that's something that could be done. And so you're saying it could be, except it's just not.
Your Honor. Well, no, Your Honor. I don't think if you're really talking about a situation where you have poll cameras everywhere all the time, I do think that could raise issues under the location tracking law. So I do think you would have potentially a legal problem with kind of ubiquitous use of poll cameras. But I also do want to emphasize that any kind of discussion of technology that is not at issue here, it's just very difficult to have that conversation because one can imagine all sorts of technology.
Sure, but I guess my concern is this. And it's sort of echoing Justice Lank and Justice Lowy, I'm not really clear on what this can and cannot do. So I'm having trouble, in my own experience, just being out in the world, I know that there are surveillance cameras, and I know that there are motion-activated surveillance cameras. So I don't think that's so far-fetched. But at any rate, I mean, I get it. Your answer is if you're doing location tracking?
Yeah, I think that that would cause a problem. But also, if there were other technologies, for example, that could, say, read lips, as Justice Lank suggested, that would certainly potentially raise issues because of, it's the same as listening to audio. So there are many ways in which, if the technology would be different, then it would be considered differently. But I don't think it's possible to do that analysis on this record. And with respect to what's missing from the record, I do think it's fair to say the parties have listed in the stipulation what the capabilities were. And I think all the parties would agree there aren't capabilities other than what is listed in the stipulation. So certainly there was no lip reading, there was no movement, trigger, there was no digital search, some ability to do some kind of complicated searching. None of that was there. It's not listed in the record, and it wasn't there.
But no, I'm asking about not necessarily what. I guess my question, I don't understand your statement that it had to be monitored by, live monitored. I just don't understand that. I don't understand why that would be. And so I'm having trouble with that, that's all.
So
why can't you just fast forward until you see something? You don't have to monitor a live time.
Well, the reason is because it's just like, a poll camera is basically identical to visual surveillance. It just is what you see. And so in order for it to be useful, you need to see it. And so you need to be, it's not practical to conduct an investigation where you just collect a whole bunch of data and then later go through it and see if you find anything interesting. Because at the same time you're doing you're maybe doing some controlled buys, maybe you have a wire, maybe you have some other kind of investigative technique. So you have to develop the information in real time in the same way that you would with any kind of physical surveillance that doesn't use any technology at all.
Oh, and perhaps I misunderstood. So these poll cameras were not recording.
No, they were recording. They were recording.
Oh, okay.
But what I mean is that it's not practical to conduct an investigation by recording for months and then later going back.
Yeah. I mean, I think we don't have to go down this road any further. But I'm not suggesting that you record a bunch of information for months and then later go back. Just to be clear. I don't have any other questions.
Justice Seifer.
Thank you. I want to go back to a more theoretical ground and talk about the mosaic theory that was in McCarthy. And I know you've made a distinction pointing out as McCarthy did, that this is really new technology, and so we're looking at things differently. And this poll camera's old, or older technology, so it really is not amenable to that. However, in the context of where things are now with technology and surveillance, when you take old technology and you drop it into the whole picture, it can become part of something oppressive, even if it's not considered to be so by itself. So I guess I'm wondering whether you think that is where you think we're headed at this point in Article 14 and Fourth Amendment law in terms of the theoretical underpinnings of it.
So, Your Honor, I understand the point you're making, but I do think that you need the record to be able to make that analysis. So if you have another case where some type of new technology was used in conjunction with a poll camera, then you could analyze, okay, was there a reasonable, violation of a reasonable expectation of privacy? How does this fit under the McCarthy analysis? But that is not this case. What you have here is solely a poll camera, a traditional technology that didn't have any fancy bells and whistles. And so on this record, I don't think it's possible to do that kind of analysis.
Okay. Can I ask you one more question? And that is, I have not read cases a lot of cases in Massachusetts anyway, where this issue has come up at all with poll cameras, but you say they've been around for a while. So why hasn't anybody raised this before?
Your Honor, I don't know the answer with respect to Massachusetts. But I will say there have been dozens of cases all over the country. And it may be that it's just that everyone assumed prior to, a few cases more recently, more Bush, and before that, the change that happened with Carpenter, that it's now being raised again. I think prior to that, there was an assumption that this was, fit very squarely under Katz and the public view principle.
Okay. Thank you.
Justice Kafker.
Justice Budd asked a question I wasn't sure you answered. Can they fast forward? I mean, they tape this thing all night, and can they just fast forward it and look quickly to see who shows, there's going to be a lot of dead time in front of the house, but can they go through a 24-hour tape and just look for when people show up? Is that part of the search process that's here?
I believe that they can fast forward, but you need to know, I think it's necessary to know what is significant, right? I mean, just because you see somebody walking outside their house, that doesn't make it important. So you need to know.
You want to see who
what you're
pulled up
looking
to the house. You can see whoever's pulling up to the house, can't you?
Yeah, I mean,
whenever someone's visiting the house. Yeah.
Yes, you could fast forward through to look for times when someone's there. Practically speaking, that's not really how it's done because it's done in conjunction with other types of investigative work.
Can I ask couple of other questions? So in Russo, I think it was 31 days of GPS. And Jones, it was 28 days of GPS. Here we've got 5 months and 2.5 months, and Carpenter is 127 days of CSOI. Don't we have a huge duration, and don't you learn more about somebody monitoring their house than you do monitoring where they're driving? So if a search takes place in 28 days by monitoring where your car goes, 31 days, doesn't 5 months of monitoring your front of your house give you that kind of mosaic of your life that Carpenter pointed out?
No, Your Honor, I don't think it does. So I certainly wouldn't dispute that, you get some personal information through with the poll camera, just as you would if there was an officer sitting there. But I think that location information is much more invasive. First of all, it's truly 24 hours in a way that the poll camera isn't, because as I mentioned, most of the time you're just looking at a house.
But most of your time your car is just parked too, isn't it? Why would you get more information from a car moving around? You're going to learn a lot less from someone's car than you are from their home, aren't you?
I don't think that's the case because you're getting a picture of throughout the day what is a person's routine. You see everywhere they go, all of the stops, any journeys that they make. So you find out, kind of the whole rhythm of the day. Whereas with the poll camera, once you're out of the frame of that camera, you have no idea what that person is doing for the rest of the day. And the other point is, I think with the public view principle, there's an idea that what you knowingly put out is public. But with location data, you have something else. It's not just what a person can see. You get this other piece of information, which, as this court has said, was previously unknowable, which is this kind of comprehensive picture of your location through time. So I think that there's kind of a disconnect between what you have knowingly put into the public eye and what you actually get from.
You think someone learns more about you from tracking your car than they do planted in front of your house and taking pictures of you when you leave and come and go and who visits you, and you really think you learn more that way than your house? And also, don't we have to give the house more protection than a car? Because the house is, your sanctuary. Isn't that different?
Yes, it certainly, there is that principle in the law, certainly, Your Honor. But there's never been, it's always been the law that, for example, an officer can sit outside your house and watch. And that's because there's been this distinction between what you knowingly, when you walk out of that house, you know that people are looking at you. And therefore, a police officer can, just like the public, stand there and watch you. So although there is that sanctity principle, there's also a well-accepted view that you can be watched outside your house.
It just seems to me that principle applies to when you're driving in public, but the U.S. Supreme Court and this court have cut back on those. That idea that everything that you do in public is public, it seems like we've changed that in Carpenter and Rousseau and in Jones, at least those concurring justices. They changed that whole view of things, but I take it you don't think so. But,
Well, I mean, certainly they established a new principle with respect to location tracking. But as I mentioned, even in McCarthy, the court said that whether something is knowingly exposed to the public remains a touchstone in determining reasonableness. So the public view principle is still alive and well. The court established a specific category of cases with respect to location tracking because it's 24 hours, because it gives you something beyond what the person knowingly puts in the public view. But I think moving from location tracking to just purely visual observation, as in this case, would be a big step beyond what this court and the Supreme Court have done before.
Thank you. That's all I have.
Chief Justice Gant, I've got some questions. The position of the Attorney General of Massachusetts is that there is no reasonable expectation of privacy in when somebody leaves their home, what they're wearing, who visits them over the course of 24/7, multiple months, that there's no reasonable expectation of privacy in those details of one's life?
Well, Your Honor, I think I wouldn't put it as a blanket statement that way. I think the question is, to the extent that those things are visible when you walk outside your house, then yes, you have no reasonable expectation of privacy once you go outside your house, if those and you are, visible to anyone who happens to walk down the street. Okay. Those things that you knowingly show the world, you don't have an expectation of privacy.
But you've made a blanket statement of principle. You said there's no reasonable expectation of privacy in the observation over the course of multiple months, 24 hours, 7 days a week, of who visits you, when you leave, what you're wearing when you leave, who you're leaving with. All of that, you say, the government has the ability to monitor over the course of many months without any requirement of suspicion or cause.
So, To the extent that it's visible, knowingly visible to the public, that's correct. I think that's a very important caveat to
Of course it's visible to the public. Yes, of course, when you leave the house, it's visible in theory to the public. But you're saying that the Attorney General of Massachusetts' position is that there is no reasonable expectation of privacy in the government watching someone's house for multiple months, 24/7, to determine when a person is leaving, when a person is returning, and who is visiting them, and how long they're visiting them for.
Your Honor, it is our position that the poll camera, as used here, it was for the 5 months.
Okay, try my question. The Attorney General of Massachusetts saying there is no reasonable expectation of privacy in the 24/7 multiple month observation of who visits one in their house, when somebody leaves their house, and who they're leaving with when they depart from their house.
Yes, Your Honor, I do agree with that. The only reason I'm pushing back a little bit is that the specific types of information you're talking about, there might be certain contexts in which there would be a reasonable expectation of privacy if they were things that you had hidden from the public. But yes, I do agree.
So the position is that the government, without going to any court and without any showing of cause, could put a camera over anyone's home for any period of time, 24/7, and that there would be there's no recourse for it, because after all, it is not a search and there's no reasonable expectation of privacy.
So as done here, that's correct, Your Honor. As I mentioned, if it were to become ubiquitous, a camera on every house, we might have a quite different situation.
Okay, so if the government had a political opponent and they wanted to monitor that political opponent's comings and goings over the course of time, the political opponent of the person in power would have no recourse in a court to say that you are chilling my right of privacy because you are now watching over me 24/7 to see when I leave, when I come, and who visits me.
Well, Your Honor, I mean, there is still a reasonableness analysis associated with, police conduct. And while that might not be a Fourth Amendment privacy claim, certainly there would be other claims, I think, that would be available to that person.
Well, like what? It's not a constitutional claim. You're saying there's no constitutional violation.
Well, I think the government can't generally just decide to target a political opponent for no reason.
If it's not a search, if it's not a constitutional search, what prevents them?
I think there is still kind of a bedrock reasonableness requirement that wouldn't be satisfied.
Well, tell me what that is. Tell me that it requires no court approval, so they could do it without court approval, correct?
I think that's right with respect to just the poll camera itself, yes.
And would there be any constitutional recourse for someone who says you have there's no good reason why the government now is watching over me in terms of who is visiting me, when I'm leaving, and who I am coming and going with?
I mean, Your Honor, I think that we're getting away from kind of what is realistic.
No, I'm not speaking about realistic. I'm speaking what the law is and should be, because as Justice Budd points out, your only constraint right now is cost. But apart from cost, is there anything that would prevent the government from putting a poll camera over everyone's home and storing the data 24/7, and having the capacity to be able to determine for any particular person all the information that I've just described?
I think, Your Honor, that would apply just as much to any other type of surveillance. I mean, in the same way you could have someone doing a stakeout at a house across the street, or in a car parked outside because the person was a political opponent.
Right, but you know full well that Justice Alito and Justice Sotomayor have pointed out that the constitutional protection there is one of cost. That there's just we couldn't have enough police officers to permit anybody to conduct that surveillance.
The same would apply here as well. there are very significant cost constraints, as I mentioned, and resource constraints associated with this technology. And I think that's why, Justice Alito and Justice Sotomayor have focused on new technology, where where the police can suddenly do something that they've never been able to do before. And that is not this case. This is traditional technology. I think can be very much equated with the person sitting out in the car outside, maybe holding up a video camera. It falls into that traditional basket.
Okay. How does your argument survive? Put aside the U.S. Constitution. Let's focus only on the Declaration of Rights. How does your argument survive Rousseau? You focused on the issue as whether it's knowingly exposed to the public. As Justice Kafka pointed out, a car is knowingly exposed to the public. You could certainly, there's nothing that bars the police from conducting 24/7 surveillance of a vehicle. But we said when you put a GPS on the vehicle, that's to breach the reasonable expectation of privacy. And in Rousseau, we did not focus on the property invasion. We focused on the reasonable expectation of privacy as the basis. So how does this differ from that? How do you distinguish Rousseau?
So I think that this court's case law under Article 14 has developed quite parallel to the Supreme Court.
That's not true. We in Augustine said CSLI was unconstitutional under our Constitution before the United States Supreme Court said it was unconstitutional under the U.S. Constitution. We said in both Connolly that a GPS on a car was unconstitutional before the U.S. Supreme Court said so in Jones. So we've been first in these areas, so that can't be true. It's not as if we followed them. We've preceded them. They followed us.
Right. No, I apologize, Your Honor. That's certainly true. But the principle, I think that the main principle of the public view principle has, even in just last month in McCarthy, the course restated that principle. And the location tracking cases have been treated separately. In general, there's a basic public view principle, and then there's this category of cases, the location tracking cases like Rousseau, like Augustine, like Connolly, that have found that when you are capturing the whole of a person's movements in public or in private, that is a separate category because it's a new technology and that it captures a level of intimate detail. And so those cases are treated differently. And this court has not held that pure visual surveillance, as occurred here, falls under that category. And as I mentioned, I do think that would be a step beyond what this court has done in the past.
Isn't Rousseau essentially the equivalent of a visual surveillance? It's identifying where the car has gone, which is the same information that you could obtain if you did a visual surveillance?
No, Your Honor. I think location tracking, whether it's GPS or CSLI, is different because it gives you a comprehensive view of the person's, throughout the day. And I think it is unrealistic in a way that is not true with poll cameras to follow a person all day, every day. That's something that's very difficult practically to do. And it gives you information beyond just, okay, I know I went outside my house, so I know people are looking at me. There's this really perfect correspondence between those two things. But with the GPS case, you're getting something else. You're getting a story of a person's day, the whole of their movements throughout the day.
When they're driving.
When they're driving, that's right. And then there's the new technology.
All you're getting is where the car is going. You're not even learning who they're with.
Right? No, I mean, it's certainly a different category, but I do think there's still a distinction between pure visual and tracking a dot through time, throughout the day, from, where they go first in the morning and when they go next and where they go next. You're not getting any of that.
So your view is that there's a reasonable expectation of privacy in where your car travels, but there's not in terms of when you come and go from your home and who visits you and how long they visit you for.
Yes, Your Honor. And it is the case that you can get that same information about who visits you and how often purely visual surveillance. And as
the same way you could follow the dot through visual surveillance and with regard to in Rousseau. You can follow the car.
I actually think that's significantly less practical to be following a car every single time, every day, wherever it goes, all the time. I think that's significantly less practical. And I do think that the courts have recognized that by telling a story of all your movements through the day, you're capturing a very unique level of intimate detail. And the court has never said that that's the case with respect to something like what we have here.
I have no further questions. Does any other justice have any questions? And hearing none, this concludes our argument. We'll break until 1 o'clock, and we'll commence our ensemble at 1 o'clock. Thank you.